So don't forget that these are the elements, right? Which you should have, I'd say, sufficient knowledge, since you have already gone through all of these elements in the letter of advice. Okay? And just to remind you, offer plus acceptance is agreement. Don't forget that, right? Now let's start with intention to be legally bound, right? We won't go through this in specific details, because we've done that already, right? But the reason why this is included, because potentially this may be asked in the examination. Remember, the questions are randomized, right? It's good to be prepared, right? Prepare your notes, PowerPoints, and also mark which page in the textbook, all right, discusses about intention to be legally bound. Okay? So when you are asked about this, any questions, whether theoretical or problem-based, that are that involve intention to be legally bound. So the first thing that you need to bear in mind is the two presumptions used in testing uh, intention. All right. If it is personal, then courts presume that the parties do not intend to be legally bound. Right. And also, if it is commercial or business in nature, all right, I'm referring to the transaction, then the court presumes that the parties intend to be legally bound. Right. You have already mastered that. Yeah. Is that right? But it doesn't end there, right? That's the problem with most of those students who failed in the letter of advice, okay, or the written assessment. Why? Because they have just simply mentioned this one without exploring, without even referring to a case law, all right? So it's not sufficient that you just simply identify this, right? You must unpack that, explore, provide sample cases, right, authorities, all right, that would support your viewpoints for that purpose. Right? Is that clear? Right. So you need to review this particular element. All right. Let me repeat that you must review this particular element of an enforceable and binding contract. Okay. Refer to case laws, right? As much as you could. The more the better. But at the same time, you need to be conscious of the time, because the time, right, is your enemy during the examination. All right. And the burden of proof, of course, you have to look at those elements here. All right. Is that clear? Any questions about this element? I am almost certain that you will be asked about this topic. All right. So if the scenario or if the theoretical question is just simply about intention to be legally bound, then you don't have to bother about discussing the other elements. All right. You won't be penalized for doing so, but you won't get any points either. So it's a complete waste of time. All right. So you need to make sure first and foremost that you have fully understood the issues involved in a given problem-based scenario. All right. Now, if there's a question, also you need to review topic about offer. All right. So what are the rules? What's an offer? Right? Who gives? What is a term? Right? Legal term for the person. All right. What's the jargon for the person making an offer? Right? If you're able to, you must use those technical terms. What's the difference between offer and offerer, right? To maximize your points. And that means you have fully, well, I'd say you have sufficiently demonstrated your understanding about this particular topic. And what are the rules, right, pertaining to offer, all right? And again, it doesn't stop there. You must cite or refer to case laws. Because if you fail to do so, now for those of you who are here, right, if you have failed to include any case laws, right, not include any sources, then most likely you must expect that you have failed the written assessment. I'm quite bold in that, because that's fundamental. All right. So what I'm saying here is, if you don't know how to reference your sources, then you're in trouble, and you will be in trouble, right, in your future, in the units that you'll be studying, right, in the succeeding blocks. It's fundamental. No matter how good you are in defending your position, if you have failed to cite a legal authority, a case or statute, then they don't hold any water, so to speak. They don't make sense at all to me, all right, as a lecturer. So it's very important to cite your source, all right. So these are the rules. You must expound that. If there are any cases, right, common law that are related to any of the rules that you can see in your screen, then you must discuss those rules. All right. Clear? All right. Now, offer and very important. Can I just emphasize that? So important. All right. What's the difference between offer and invitation to treat? There is a big distinction there. An offer gives rise, if accepted, an offer gives rise to a binding agreement or contract, right? Whereas invitation to treat do not. In other words, right? What's the effect of invitation to treat? Hmm? You recall that? And you should have discussed that in your written assessment, right? What's the display, of all the products that Big Mac was, displayed in restaurants, whether electronically or in within the restaurant. Okay, is that an offer or invitation to treat? So you should be able to distinguish between the legal effect of an offer if accepted and also invitation to treat. All right, here are some examples here. All right, and the cases, you must discuss these cases when you are asked to explain what an invitation to treat is as opposed to an offer. Discuss these cases. All right. Is that clear?
Ryan,
Yes.
does it have to be all the cases or just one of them?
The more the better. Or if you only say, for example, if this is as in the theoretical question in part A, which is 10 points, if you only mention pharmaceutical society, you will only get 5 or even less or even just 6 perhaps, depending on how you have explored it, right? But if you have mentioned these 3, because there are also other cases that are not included in this line, but if you mention those also, then you may perhaps get 10 points. All right. So, but you need to strike the balance between quantity and quality. You may have mentioned these cases, but if your discussion, all right, or your elaboration is quite confusing, then perhaps you won't get as much, right? So, quantity and also the quality of your answer, all right? But take note that you should first and foremost be able to identify the relevant cases, all right? That's the first thing. And then work out on how you can better explain or explore those, right, to support your arguments. Is that clear? Did that answer your question, Akon?
Yeah, thank you.
Excellent. All right. And further to that, all right, very important case when you talk about offer versus invitation, the case of Carlyle and Carbolic. So what is this? So the only exception in which an advertisement could constitute an offer. You remember that case? The smoke ball? Who remembers that case?
Yeah.
So there was an advertisement about the smoke ball that would, it would treat your influenza. And if you follow the instructions, you won't be able to contract influenza again. So what was the other the other condition provided, or was there a reward? In other words, yes, there was a reward, right? So in other words, Carlyle was, I'm sorry, Carbolic, the manufacturer of that smoke ball, said that if you contract still influenza, After following the instruction, you're taking the medication, using the smoke ball, then we'll give you a reward. Was it 100? Like, yeah, I think 100. So the court said it's not only an invitation to treat, right? So it was, as a matter of fact, an offer. Now, therefore, since it was accepted by the customer, then it gave rise to a binding uh, agreement. Okay, remember that. So you must mention this one. Okay, an exception where an advertisement could constitute an offer, not only an invitation to treat. Okay, so look at those impositions. Is that clear? All right, excellent. Now, acceptance, uh, which is an element of a legally binding and enforceable contract, may also be asked in the examination. It's examinable, definitely, right? So you must define the term first, right? Same as true for the rest, right? What's an offer? Define it first before you discuss the cases, and even intention to be legally bound. What is it? What does it mean? All right. So acceptance, define it first, and thereafter you have to provide the rules, right? Now these are the rules, and if there are any cases under each rule, right, relevant case or cases for that matter, you must also incorporate that in your discussion, right, to maximize the points. Right, clear? Okay, excellent. So any questions so far? All right. Now consideration, right? First, like I've mentioned earlier, you must define what consideration means, right? Very important, right? I'd say. Okay. What is it? And what are the rules? Just like the other elements of a legally binding contract, there are rules for most, if not all, of those elements. And also associate some relevant cases. Okay. So definitely you must review the rules pertaining to consideration. Okay. So these are the rules, as you can see. Oh, I don't know why I have uh, made these some rules. The texts are in red, so that could be a signal for all of you that this is an important rule pertaining to consideration. It could come out in the examination. Right. So we've discussed about that consideration shall only be either executed or executory, right? Not past consideration. Right. So you must review this case, the case of Riscorla and Thomas, right? In which the buyer of the horse asked for an assurance that the horse was free from any vicious characteristics. But it turned out that the horse had these undesirable characteristics. But remember, the question was asked after the contract was what? Formed. Okay. So the court said it was not supported by any consideration. You could have asked prior, but since new terms were added after the contract was formed or after the contracting parties entered into a binding contract, then that assurance was not valid. Okay, so review that. And also review the case of Silk and Myrick. Okay, consideration. What about if you're asked to do some work, or additional work, so to speak? Okay, so you have to ask yourself first and foremost: is this new work, or well, I'd say, is the task given to me, right, required from me, part of my contractual obligation, or not? All right. If it is part, then even if your boss has promised to give you extra pay for that, right? But if eventually the boss reneged from that promise, the question before the court is it part of your contractual obligation or not? If the answer is in the affirmative, if the answer is yes, then the boss will not be, all right, obliged to comply with the promise he made. But if it is not part of the contractual obligation and you did that particular task and the boss promised you extra pay, then the court will most likely compel the boss to pay you extra wages, right, based on the promise provided. Right? Is that clear? So know the distinction between the case of Silk and Myrick and also the case of Ponsonby, right? Was that clear? Do you recall that? You don't recall that anymore. But yeah, you have to review. That's part of your uh, obligation as students. Okay. Any question? So there are rules, as I mentioned, but rule number 4, it is worthwhile to look at this, to review rule number 4 of consideration. Okay. Consideration can be nominal and need not be adequate. So in other words, if you sell your house, which is worth $1 million for only 100,000, right? Is that acceptable? Right? Yes, it is acceptable, provided that your consent was not vitiated when you enter into a contract. In other words, you were not drunk, you were not intoxicated, you were not of uh, you were not suffering any forms of mental disorder, right? That would impair your judgment when you enter into a contract, right? If that is your will, you have given that freely, and there was consensus. Selling your house for 100,000, which is too minimal, it's fine. Right? The law will recognize that. Okay, and that's what it means by rule number 4, right, of consideration. Clear? Any questions? Staple, of course, is very important, right? So you must, first of all, define what it means, and also the two types of staple: the traditional one and also the promissory, which is in the future, right? So explain that, right? And very important concepts under staple is reliance and detriment. So what does it mean? You recall the case of Central London and also Maher and what's the other party? It's actually in the next lines. Walton Stores. Yeah. So if there is a question about staple, you must mention the case of Central London, right? Because that is when the court first and foremost identified the new concept of staple, which is promissory staple, right? So remember, so there was war during this time, and then Central London, uh, was it? Yeah, Central London, and High Trees entered into a new arrangement, lowering the rental fees during that period. Okay. And when the war was over, so the economic activity was restored, and then Central London said, all right, we might have to revert back to the original rental fee. All right. But High Trees did not agree to that. What did the court say? No, you can't do that. Right. Why? The condition there was the fees was only lower during the war because there was no economic activity. So all these properties were actually not rented out. Right. Now that everything's back, so you have, all right, Central London has the right to demand from you to revert back to the original rental fee, right? And after all the properties were actually occupied. Okay, but what if Central London asks for back rent, right? What did the court? What was the obiter dicta? What was the opinion of Justice Denning at the time? No, you can no longer do that, right? Why? Because that was an agreement. You are actually bound by what we call promissory estoppel. So to put that simply, right? I've explained this one early during the session when we discussed this, right? So if you suffered from financial losses or whatever, facing financial difficulty, and your landlord says, okay, I'll lower your rent to 300 from 500, right, for 3 months, just to help you out, okay, and then both of you agreed to that arrangement. So 4 months after, for instance, your landlord says, okay, I changed my mind, right, I'm claiming the back rent for that period. Can your landlord do that? Applying the case, your landlord cannot, right, on the basis that he is bound by what we call promissory estoppel. He can no longer change his mind, right? It would be, that's why you look at the detriment and reliance. It would be detrimental for you because had he not made such new arrangement, then you could have find another space, right, a cheaper one. Is that right? Or that's why you have relied on the promise, right? So you remain in that property on the basis that the rent was actually lowered or lessened, reduced. All right. So these are the cases that you need to mention, right? If there are questions about consideration and promissory estoppel or estoppel in general. Is that clear? Too much? All right.
Yeah, clear.
Excellent. Now you also need to review, right, the topics concerning the contents of the contract or contractual terms, in other words. So there are express terms. What are express terms? Define it first and foremost. Those terms that are either verbally stated or expressed or written in the actual contract. So anything that was stated or written, right? Those are express terms. So our verbal contracts can be enforceable? Can they be? Of course, they are as enforceable as the written ones, except for those well, there are exceptions, but you don't have to worry about those. But generally speaking, unless the law or unless otherwise provided, unless there is a legislative requirement for a contract to be in writing, right? Verbal contract or contract can be as enforceable as written ones. But what's the risk there? What do you think? For those of you who have remembered, what is the thing that we need to remember when entering into a verbal contract? What's the risk there?
No evidence.
Sorry?
No evidence.
Yeah,
Evidence.
that's right. Yeah. So if disputes arise, all right, so there could be evidentiary problem there, right? You may not be able to provide sufficient evidence if you are the aggrieved party, and even the other party could not provide, may not be able to provide strong evidence supporting each other's claim, right? In the case of Bakinara, right? So there are also implied terms and there are rules, right? So those are that are not expressed or written in the contract, but may form part of the contract under the express provision of the law. Now, just on the uh, verbal contracts, okay, what's the rule pertaining to uh, parole evidence? You remember that? Very important. Parole evidence. If I say important, that means we have included this in the examination. What is parole evidence? You remember that? Or oral evidence? What is the rule pertaining to that? Hmm? Anyone?
Is it the one that it cannot outweigh the writing evidence if it's signed?
You cannot say that again, Calvin. You
You cannot
cannot
outweigh the writing evidence with the oral evidence if the document is signed.
is signed. Okay. So what you're saying is the court will not allow either party to present oral evidence. Is that right? Is that what you're saying? If the contract is a written one.
Yeah.
Okay. Anyone who agrees with that statement or disagrees? Or no one cares anymore. It's the end of the, the block. Okay. Anyone who would like to explain that? Or maybe add on to, would you like to make any comments, Joshua?
No, I was saying I actually forgot about the parole evidence. Like I won't lie, a little bit, because
So-
I didn't use it in my written case study.
Written assessment, yeah. That makes sense, yeah, but please, for purpose of the exam, review parole evidence. All of you, please, please, please. Right, what is it? So if the contract is wholly or entirely in writing, right? Writing, okay? Neither party can give verbal evidence that would add to, vary, or contradict the written contract. So in other words, what's the point of entering into a written contract if sooner or later you will assail the contractual terms provided therein? It would be a chaotic world that we will be living in if that is the case, right? That's why, just to remind everyone, if you enter into a written contract, right, you are bound by the terms, right? Unless you fall under the exceptions, but generally speaking, you're bound, even if you haven't read the contract itself. Okay. So there's no point of allowing you to provide oral evidence, verbal evidence. Okay. Why? Again, there's no point. If that is the case, then we don't have to perhaps enter into a written contract. All right. So be very careful when entering into a written contract. But there are, of course, exceptions. Right? Did you get it? Did you understand what parole evidence means? That rule? Okay. So there are exceptions. All right. Customer trade and trade usage, which you must review. Remember the farmer. We don't need to explore that again, but the farmer. And also there's verbal condition precedent. It needs approval from the engineer, right? Before we proceed with the arrangement, right? So what happens, that condition, what happens if the engineer or should the engineer disapproves the invention? Of course, the contracting parties won't be able to proceed with the execution of the contract. So there's condition. These are the exceptions. Okay. Terms are ambiguous. Okay. Contract is part. This one important, but I'll explore that later on. But terms are ambiguous. Okay. So you may have entered into a written contract, but if the terms are susceptible to many interpretations, or if not, it's too complicated that even the court won't be able to comprehend what it says, then the parties will be allowed to or permitted to provide oral evidence. Identity of party is not so important. It's for the companies. Okay. Now let's just look at rule number 3. Contract is partly written and partly oral. What does it mean? Okay. So in certain circumstances, the courts will decide that a contract is partly written and partly oral. Despite the fact that there is a written contract, right? If these circumstances are present, okay, then the court will allow oral evidence. So what does it mean? Right? So let's look at the two cases. You remember the case of Vanden Eschard and Chapel, the white ant infestation? You don't recall that? Anyone who remembers, apart from Joshua, who's nodding? So what was that case all about? So they were about to sign a written contract, yeah, a contract of sale, transfer of property, yeah, remember? And prior to signing, Van den Eschert said or asked for an assurance. Can you assure me that there is no white ant infestation in the property? All right. So, and of course, the owner said, yeah, I can assure you, I can guarantee you that. And then thereafter, they signed because it was a written contract. But what was the result? It turned out that the property was actually infested with white ants. All right. So, of course, Van den Eschert sued, and Chappell said, well, it's not in the written contract. Okay. All right. But fortunately, Van den Eschert successfully provided strong evidence to the effect that there was actually that statement assurance before the signing of the contract. So timing of statement is important in this case in order for you to successfully, right, claim this particular legal argument. So timing right before signing, right? And the other important aspect is the relative importance or significance of the statement. So the question is how important it is, or that the property is free from any white ant infestation. Very important, isn't it so? All right. So what if the assurance sought was, can you make sure that all the light bulbs were working? Is that important? Not too important if you're only referring to bulbs as opposed to white ant infestation. Is that right? Because you can replace them. All right. So think about the importance of that assurance, right, in the examination, if you're asked about this. There was also the case of De La Salle in Guilford. Right? So I think it was Guilford who wanted to rent out the property. Okay. And prior to signing, right, there was an assurance sought. Right. Are the drains working properly? Right. And of course, De La Salle said, yes, they are. But it turned out that they were not. Okay. But here, the parties argued for the existence of what we call, what was that, collateral contract. It's similar to exception number 3, but it's just that during that time, the aggrieved party, the plaintiff, okay, use another argument, right? But you don't have to be too technical in your examination, right? Nevertheless, you must mention these 2 cases, very important cases or authorities, right, when discussing about parole evidence. Is that clear? Exceptions. Exception 3. All right. So where are we? Where are the questions? We're supposed to do the, all right, nearly. So there's also misrepresentation. Okay, sorry. Yeah, misrepresentation, which is examinable as always. All right. We have always been asking about misrepresentation, but be very careful in discussing this. Okay. So the case of Oscar Chess and William is the leading authority about misrepresentation. These are statements, right, that may be, well, that are deemed to be true when in fact they are not. Right. So it's an equitable remedy for the innocent party. However, it varies from remedies for breach. You may be entitled for compensation or to repudiate the contract. Right. But just to simplify, let's look at the case of Oscar Chess. Right. You remember this? So here, Williams was trading off his car. Right. He was so convinced that the car was a 1948. Oh, in 1948, when in fact it was 1939. Okay. So he was innocent, right? So he did not, by all means, misrepresent himself. Okay. Or providing misrepresented or untrue statements or information. Okay. So, well, of course, Oscar Chess believed him. All right. And in fact, it was that was provided in the documents, which was unfortunately forged, right, or manipulated. Right? So now Oscar Chess found out that the car was actually 1939, and of course, they have demanded for extra pay. Why? Because the older the car, in most cases, right, the lesser the value. Isn't that so? Right. So Oscar just, oh, you have to pay us extra because you said it's 1948. It's 1939, so pay us maybe 200 more whatsoever. But William said no. That's what the information that was provided to me, right? And also the documents provide that. Okay. Now the court said, unfortunately, Oscar Chess, you have to bear the losses, right? Because William was innocent in providing those claims, right? It was the previous owner who actually uh, manipulated or changed the information, right? Forged the information in the document. So they have to bear the losses. So these are the factors. The objective intention of the parties. Was there an intention on the part of Williams to misrepresent or provide untrue statements? The answer was no. The actual words used, okay, and the proper inferences from known facts, right? So no fraudulent intention whatsoever. And whether the statement was reduced to writing, was it in writing? Well, this is not relevant in this case, right? And the comparative knowledge, all right, skill and knowledge of the party. So what does that mean? So the court was saying that, well, you, Oscar Chess, you are the dealer, then you have more knowledge than William. So you should have double checked that everything was in place and the information was actually, in fact, uh, true. Okay. So you have to review misrepresentation. So just going back on contractual terms, remember there are three categories, right? And regardless of the category, so each contracting party must comply with the conditions, warranties, or the innominate terms, which can either be condition or warranties. But let's focus on the first two categories, right? Don't worry about the third one, right? But this is nevertheless important. Okay. So what's the difference between a condition and a warranty? Remember? So whenever you hear this type of or category of contractual terms, always think about the case of opera singers. All right. Remember those? Always think of those cases. Right. Condition is the fundamental term of the contract. Right. The case of Possard and Spears. Possard could not perform during the exact date and the time of the event. You remember? She could not sing because she was in the world. So what happened was the company, the organizer, terminated her contract. Why? Because Possard has breached the condition. What's the point of having a concert if the performer could not perform or could not sing? Right? So failure to comply, the condition will totally, all right, change the contractual arrangement. Right? So if you breach the condition, then therefore the other party can repudiate, can terminate the contractual term. Is that right? The contract, sorry, the contract. So if you are confronted with issues such as this, you have to ask yourself, how important is this term? Ask that question. Is it too important or not? All right? Because it could just be a warranty. What's warranty? It's still a very an important uh, contractual term or category of a term, but not as important as a condition. Why? So you are still, you know, bound to comply with the warranties. These are the cosmetic or structural aspect of the contract. So again, the other case of opera singer. Remember, The case of Bettini. Who recalls that case? Who recalls that case? The other.
Turned up
Yes,
2 days
Nicole.
early instead of 6.
That's right. So, could she still perform or sing during the event?
Yes.
Definitely. All right. So, in that case, the company cannot, right, terminate the contract. Why? Because she still can perform and sing, but she may be liable for damages. Okay. Is that clear? Any questions? So again, these are all part of this topic here, right? Parole evidence, contents of the contract, right? I need to emphasize this. So discuss this, and exception 3, parole evidence. Even this one you need to, and the concept of condition and also the concept of warranty. Is that clear? Excellent. So what are the remedies? I've mentioned this already, right? If you breach the condition, if you fail to comply with the condition, then you can again rescind, repudiate, or terminate the contract. Plus, you may be entitled for damages. If you have only breached the warranty, you cannot, by all means, right, terminate the contract, but you may be entitled for damages. All right, no problem. Someone's have to leave. That's all right. Okay, now here's the practice exam. Yeah, before you go, oh, he's left anyway. So we do breakout room. Let's attempt this. I'm telling you, it's very close to the actual examination. Right. One of the options, one of the questions, the randomized. Right. So I'd like to urge you to prepare for this one. Okay. So what we'll do is let's do a break. How many are we? 3, 6, 9, 12, 13. Okay. So maybe 3 groups. Okay. So, but before that, all right, let me ask someone, any volunteer to read the practice exam question, please?
Yeah, I'll read it.
Yeah, thank you. And there's another one, yeah, but we'll do this one first. Okay. All right.
Jason wants to buy a used car. He knows the make, model, and color of the car he wants to buy. He visits several car dealers who can supply the type of car he wants. Jason notices a red Toyota VU displayed at Ring Car dealer owned by Gary. Jason is extremely attracted to the car and thus very keen to purchase it. He has one concern though. He would not only purchase the car if it is less than 3 years old. Gary has assured Jason that the car is only a year old. On this basis, Jason purchased the car and signed the contract, which does not stipulate the age of the car. A week later, Jason discovers that the car is actually 5 years old. Advise Jason.
Sounds familiar?
Mm.
Right. So if you are attempting a problem-based question, what is the first thing that you need to do? What's the method that you need to utilize?
The issue?
So use the IRAC method, all right?
Yeah.
So for purposes of this practice exam question, identify the issue first and the relevant rules and how would you apply it, right? But maybe not so much with the application at this stage, right? But let's look at the relevant rules, very important, okay? What do you think? Okay, so we'll do breakout rooms, okay? Discuss all the legal principles that you can think of insofar as this problem-based question, the scenario is concerned. Okay? So I'll give you say 15 minutes. Is it too much? Yeah, maybe that's sufficient. Right. And then we'll go back to the main room and I'll ask you, whatever discussions that you had. Okay. If you don't provide me any answers, then I won't be able to help you then. Okay. All right. Let's create 3 breakout rooms.
So everyone left. So that's the end of the video.